We start with the Don Blankenship trial, where yesterday the jury came back, once again said it's deadlocked, and so the judge, Irene Berger, used the Allen charge, named for a U.S. Supreme Court decision from 1898, which provides for what you would call gentle coercion, if you will, or a moderate coercion, instruction to the jury to go back to work, examine your findings here, and examine your own conclusions, and continue to work and see if you can come up with a verdict. To discuss this, Jeff Jenkins, who's been covering the trial the entire time, joins us from our Charleston studios, and on the phone is Harvey Peyton. Harvey Peyton has been our legal consultant on this. Harvey, let me start with you. So, again, explain for those who don't know, we've been through it, but the Allen charge. What is the Allen charge, and why is it significant in this case at this point?
Well, the Allen charge, as you said, stems from an old Supreme Court case in which the trial judge, who has the discretion to stop the jury deliberations if it appears that further deliberation is fruitless and to declare a mistrial, also has the tool of mild coercion to assert against the jury, to call the jurors in when they say they've reached an impasse and say, look, I mean, I'm paraphrasing.
Yeah.
You know, this case is going to be decided sometime, ladies and gentlemen, and you've worked hard, and it's been a long and expensive case, and someone has to decide this case, and it's going to be people just like you. No one's more qualified. We're not going to get anybody any better or any worse the next time. And if you are in a minority, and it was included in Judge Berger's charge yesterday, a specific mention to the jury, if you are in a minority position, you have a duty as a juror to consider that. Consider, well, let's look at the majority opinion and weigh that against my thoughts. Are my doubts reasonable?
Mm-hmm.
And so insofar as it actually calls out to a degree, of course, we don't know how the jury's divided, and it would be inappropriate. It might be 6-6, in which case that falls on just deaf ears, but if it's 10-2, it's pretty clearly a direction by the court to the jurors. You should do your very best. I mean, look at the majority opinion and consider, are you out of step? And then the other thing that Judge Berger said was, you know, you don't have to decide all three counts, which may be something that's holding the jury up as well. But it's encouragement to the jury once they've said, you know, we've reached an impasse, to say, look, try again, and here are the reasons you should try again. Here are the policy reasons you should really try to resolve this case.
And can you come up with a verdict or verdicts without giving up your, quote, personal scruples? So
Right.
is there a way, and again, this is a direct, I think this is interesting, Harvey, because it's a direct charge to individual jurors. I mean, you're sitting there and you're hearing it and you're thinking, she's talking to me.
Right. It's not the general charge to the jury. This is speaking to the jurors, not the collective entity, the jury. This is to you, ladies and gentlemen. Let me tell you how you should now consider your position, and if you can do so without giving up a strong personal conviction, arrive at a verdict.
Yeah. Now, Harvey, of course, the defense again immediately made a motion for a mistrial, which the judge denied because, as you have pointed out, and you've done research on this, that the U.S. District, 4th Circuit, West Virginia's a part of, that has historically given a lot of leeway to the district judges in this case to run the trial, to make these kinds of decisions. And in one case you referred me to, the Allen charge was actually given by a judge twice, and that decision was upheld by the appeals court.
It was, and that's sound reasoning. No one is in a better position. No one in the world is in a better position to evaluate the manner in which the evidence was presented, the manner in which the jury received the evidence, because they sit in a jury box directly in the judge's line of sight, the nature of the testimony, than the trial judge. I mean, that means a lot. I mean, it's overlooked a lot of times, you know, and when you talk about appeals and you talk about a cold record, but the very best person in the world to judge the nature of this trial and the dynamic is the trial judge, who hears everything and who sits and looks at the jury. I mean, she, as a witness is testifying, you know, the jury is seated in a box to the judge's right. The witness chair is to the judge's right. As she sits and listens to a witness's testimony and looks at this witness, she looks right over their shoulder at the jury and has an opportunity to see and to know these folks. So her determination, the determination of any trial judge, is given great deference by an appellate court.
And that's what the appellate court has done historically. And as I pointed out in that case from a few years ago, they actually they denied a motion for appeal based on the fact that instruction was given twice, and the court said, well, we're going to defer to the local judge here. Jeff Jenkins, this instruction came, this Allen charge came yesterday mid-morning during the 7th full day of deliberations. You were there yesterday afternoon, you and Shauna, when the jury came back, because they went back to work, had lunch, came back to work, deliberated during the afternoon. And not to get too psychobabble here, what did that jury look like when they came out of that jury room?
Oh, they didn't look happy. I mean, and I'm not the only one that noticed that. I mean, it seemed to be a pretty general consensus. They looked tired, and they looked, when you send that, I think the wording in their question is very interesting, Hoppy.
Okay.
The wordings they've had. All right, when they asked the judge last week or whenever it was, maybe almost 2 weeks ago now, to define, condone, and strive, that wording of that question was some jurors, not all of us, some of us, want you to see if you can further define this for us, Judge. Okay. All right. So to me, that sends a rift. Like, why can't all these people understand what this means? Yeah. And then yesterday you get the question: can you give us further instruction? We're deadlocked. Can you give us further instruction? Which it's almost like some of them are very ready to do whatever they were going to do, but others are just holding them up. And obviously, they're deadlocked, and so they go in after lunch. Now there was some discussion that why didn't the judge just send them right in, and right after that charge, and have them talk, but instead it was lunchtime, and she allowed him to go to lunch.
You can't deny him lunch.
Yeah, and then she came back in. There was just some discussion that maybe it would have been, hey, Hop, we're hanging down there for hours, right?
I understand. Okay.
Talking about a lot of stuff.
There's a lot of time to fill.
But I talked to one of the UBB family members afterward yesterday, and they also said, they said Shirley Witt, whose brother Boone Payne died in the Upper Big Branch explosion. She said for the first time, she saw frustration on the faces of the jurors late yesterday when they dismissed them for the day.
Well, I would think that's going to happen. I mean, Harvey, these folks have been at it now for more than 7 full days. They've been at this trial for 2 months, and they're at a point where clearly they are deadlocked. Clearly they can't resolve some issues here, and clearly they got to be frustrated. So I don't know whether this Allen charge makes a difference. Do you think it will?
Well, I think it makes a difference because it's the judge's last tool in her toolbox to try and encourage these folks to resolve their differences. And maybe you never know what effect it will have on an individual juror, but if it gives a jury an out, to surrender some mild reservation about deciding a case one way or the other, then it will help. If the folks are set, literally any lawyer that's tried many cases, if they're hard-fought cases, have seen jurors come back and arrive at verdicts who are visibly upset with each other, and who are crying.
Yeah.
Some of the jurors will be crying when they answer a question, yes, it's my verdict, and they're hesitant to do it. It's not an easy thing to do, but if you've got animosity, and it's a terrible shame if this case results in a hung jury. There's tremendous resources on both sides.
What happens, Harvey, if it does? What happens if the jury comes back? I don't know what the reasonable period of time will be, but obviously it gets a little bit shorter now after the Allen charge. We are hopelessly deadlocked. We're deadlocked. We can't reach a decision. And if a hung jury is declared, what does that mean?
Well, then the judge discharges the jury and declares a mistrial, and then the burden shifts to the United States attorney to make a policy decision whether to, again, prosecute the case. They don't have to. They can elect to simply dismiss the charges, or they can elect to do nothing. The judge is going to set the case for trial. Once she declares a mistrial, she will immediately or shortly thereafter set another trial date. Then the question becomes with the U.S. Attorney's Office, having given this our best shot, are we going to retry this case?
What do you think the federal government does? If, in fact, there's a hung jury, thus a mistrial, which is not an acquittal, it's a mistrial, means the charges still stand, does the federal government retry this case if there is a mistrial?
Well, they probably do. Then the question becomes, where do they try it? We gave it a try in the Southern District of West Virginia and got a hung jury. And, based upon what we now know, we don't know anything about this jury because the selection took place in secret, but because there were so many disqualifications of jurors to seat so few to hear the case, based upon sound research, that indicates longer deliberations. It may indicate that there's just an underlying bias on some jurors that can't be overcome. And maybe, would this case be better? Would judicial economy be better served by moving this case to Martinsburg or to some other point of holding court within the Fourth Circuit, which could be as simple as Alexandria, Virginia, or
somewhere in Maryland or something. Right?
Sure. They used to send cases to Baltimore all the time out of West Virginia for politicians.
So there would be, but certainly the defense would make a motion again. I forget if they did the first time or not, but they would make.
Oh, sure, they tried to get it out of here with all that was in them,
But now but now they could certainly make the motion and say, look, we have reams of recordings of TV and radio and newspaper clippings and talk show hosts about this thing. Yeah. So we got to move this. We got to move this. Got to move this case.
Hoppy, here's a question.
Yeah.
Well, the judge yesterday, and it's kind of interesting how both sides have kind of switched their thought on this. And the judge yesterday did tell the jury that you don't have to decide on every one of these. Basically saying you can hang on a couple of these charges if you. And
that's the first time she told them that, right?
It is, and so now both the prosecution and defense kind of feel differently about that now. At first they, that was going to be part of the defense's instruction that they proposed to the judge, and now when they think that they might be cleared on all of these things, they're not for it, and the prosecution agreed yesterday to have the judge. You did not disagree with the judge that should be given to the jury because they're trying to get anything.
Yeah, so kind of a flip there.
Yeah,
Harvey, what do you make of that?
Well, I think Jeff's exactly right. I mean, when you think you're going to get the whole loaf, you're not going to give the other guy half. And now, you think the government's thinking, we've got a dunk here. The evidence came in pretty well. The defense didn't put on any testamentary defense. We're not really wanting this jury to compromise. We'd like to have a clean sweep. And now the defense was looking at that time for we'd be, if we can get an acquittal on a couple of these charges, then we'll have a narrower field of attack on appeal. And, of course, now that's flipped.
Yeah,
the defense thinks, we're in good shape either for a mistrial, which is a tie, or, or an out-and-out acquittal. They don't want to give the jury an excuse to get off the hook by saying, well, let's just – and the real risk is what appears to be the most innocuous charge, this press release to the shareholders, if that would happen to be the jury's compromise, they don't know what the punishment is.
Right.
The jurors, that's a 20-year maximum sentence. Yeah. I mean, if they convict the fellow of one count of conspiracy to willfully violate mine laws, they don't mark the box for the second conspiracy. That is the fraud against that's a misdemeanor.
That's up to 1 year. Yeah.
Yeah, he can walk away convicted of a misdemeanor, punishable by a $5,000 fine and up to a year in jail, which probably guidelines out for a person with no prior criminal misconduct at probation.
Yeah.
Well, at that point, Mr. Blankenship may well say it's time to call in the dogs.
Yeah, because of the three counts, and the count one has two parts: violation of mine safety laws. That's a misdemeanor. Up to 1 year in jail. Then there's obstructing MSHA, and that's up to 5 years in jail. Then the count two is the Securities and Exchange, committing fraud by essentially lying to the Securities and Exchange Commission about the safety policies at Massey, and that's up to 5 years. And then lying to investors, including omissions there, and that's up to 20 years. So and they don't, as you say, the jury, it's not in the instruction as to what the penalties are. So now the fact that they were told yesterday, Jeff, that for the first time, and maybe they assume this, or you don't know what they're thinking, that for the first time that you could not do something on one of them and do something on another, is maybe that breaks that log jam, that they say, okay, we'll convict him of one, but do nothing on 2 and 3, or convict him on 3 and hang on 1 and 2, or whatever. There's other options there now.
Yeah, but they had 3.5 hours to do that yesterday, and they didn't do it. So, I mean, so the thought is if they're it's just conjecture, but, the thought is maybe they could get that done. I mean, there were some observers who thought yesterday that, they'll come back. They'll come back this afternoon. After getting that Allen charge, maybe they're very close on something, they'll come back, but they didn't.
So, Harvey,
that helps the government. That helps the government. If one of the things the appeals court looks for in determining whether a jury is coerced is once they receive an Allen charge or a dynamite charge, how long then do they deliberate? Had the jury gone out and returned within a few minutes with a guilty verdict on one count, one might perceive that as having been coerced. But if they now retire, I mean, the defense would have to be concerned about this. If they deliberate and come back with a verdict this afternoon, say, after another 6 or 7 hours of deliberation, and convict Mr. Blankenship on one count and acquit him on the others, certainly the idea of coercion or any problems with the jury selection or deliberation are off the table for the defense as an appellate ground. Because it would be obvious that the jury was not coerced. They were simply encouraged to do their job more thoroughly.
Hey, finally, and I'm late here on the break, but finally, Harvey, just from 30,000 feet here, why are we at this point? Why do you think we are at this point?
Difficult case, a lot of testimony, a lot of technical testimony, a lot of documentary evidence that needed to be reviewed, and because we're trying the case where we're trying the case, and we selected a jury in the manner in which we did, I believe, it was a case built for long deliberations and difficulty deciding. And you mix that with really good lawyers on both sides, and it's, it would take my estimate, watching the trial every day, it would take a set of strong leadership types on this jury to lead them through the Red Sea, to bring them out on the other side on this one. At this point, I just don't think they're going to get a verdict.
You think it's a hung jury? Well, clearly the jury's hung up. Is it going to be a hung jury?
It's not going to be a unanimous verdict on all counts, that's for sure. There may be a conviction on one and a hang on a couple, but right now it appears to me the odds are in favor of this jury going at it again for another day. And if they come back again after another day's deliberations and say, Judge, we're still just deadlocked, I don't see what more the judge can do.
All right. Harvey Peyton.
But I'm not the judge. She can do what she wants to do.
I understand. Harvey Peyton serving as a legal analyst. Jeff Jenkins and Shauna Johnson covering that trial. Shauna's down there now. Jeff will be down there this afternoon if necessary. More at our website, wvmetronews.com. Harvey and Jeff, thank you very much.
See you, Harvey.
Thank you.
All right, we'll be back. Stay with us.